Master organized by the Institute for the Study of Judiciary, Politics, and the Media here at Syracuse University, or IJPM. And one of the things we like to do is turn on cell phones right at the beginning. This lecture series, which will be running throughout the entire semester, is designed with the idea of introducing students and faculty and members of the university community to issues of law, politics, and media as a single integrated subject of study. So rather than going to law school and hearing someone talk about legal principle, or going over to Maxwell and hearing somebody talk about politics and decision making, or Newhouse, media coverage, to break down the divisions between these individual academic silos and talk about this single integrated phenomenon as it actually happens in the world. There's a course associated with this lecture series, and that meets on a weekly basis, but the lecture component is open to the public. And today is our first lecture. We have with us, fortunate to have with us today, Rebecca Kourlis, who served on the Colorado courts for nearly 2 decades, first as a trial court judge, and then as Justice of the Colorado Supreme Court. Justice Kourlis left Colorado's High Court in January of 2006 to establish Institute for the Advancement of the American Legal System, IAALS, or IALS, as they're known around Denver. IALS is affiliated with the University of Denver, and Justice Kourlis is the executive director. IALS is a young organization, but it's already achieved some recognition as a national voice for civil justice reform. Recently, IALS was named a Legal Reform Organization of the Year by the U.S. Chamber of Commerce. And IALS has also done a number of other things, including conducting surveys to get a sense of voter knowledge and perceptions of the Colorado Judiciary, and also to inaugurate what I gather is going to be an annual award on transparent courthouses, the Transparent Courthouse Award. And the first recipient of this award was Justice Sandra Day O'Connor. And this award was given to her in recognition for a lifetime of work promoting excellence in American courts. Justice Kourlis earned her BA in English from Stanford University and her JD from Stanford Law School. And today she's going to give us a lecture entitled Building Transparent Courthouses, Accountability Through Strong Judicial Performance. Please join me in welcoming Justice Kourlis.
Thank you for the opportunity to be here. I hadn't realized that this was the inaugural lecture. Raised the level of demand here. I have to try to launch you all in the right direction. I do want to emphasize before I start into my prepared remarks that particularly in a setting that is like this one, and where there are a number of you who have familiarity with these topics and who are studying them thoughtfully, and we can all participate in a conversation without having to yell at each other. I welcome your questions, comments along the way, or you can save them. We'll have a question and answer session at the conclusion of my remarks. So let me first thank Keith for the invitation to be here. This really is an honor. I have to tell you, however, that I thought the name of our institute was a mouthful, and you guys come awfully close. The Institute for the Study of the Judiciary, Politics, and the Media, and we are the Institute for the Advancement of the American Legal System. So it's a toss-up as to which one is more difficult to remember. I would also like to thank Kyle, who's going to run my little mini media piece midway through the remarks. We have a director of communications and marketing at the Institute who is of the view that never, ever, ever should I stand up and give a speech without some sort of interest factor. And so, indeed, I have a little television clip that I hope will illustrate some of the points that I want to make and also generate some questions. So I want to begin by talking to you about something that is very familiar to you because you wouldn't be here if you weren't good at it. And that is having your performance measured. We measure everything in this country. We buy cars on the basis of miles per gallon. We look at P&L statements, earned run averages, SAT scores, returns on investment. Measuring success or failure is the way that we determine whether something is a good investment, is a good opportunity, or whether someone has indeed performed their job well. It borders, I would suggest to you, on a national obsession. We measure politicians by the legislation they pass and public opinion about how they handle pressing problems. We believe, and here's the real key to it, we believe that we get what we measure, and that government accountability through measurement is essential. But despite this yardstick mentality that shows up every place else, we rarely measure the courts. Instead, the usual response to measurement in that arena is that it simply can't be done, or worse, that it shouldn't be done, that our judiciary somehow floats above such routine and mundane tools as measurement might enhance. I'm here to tell you today that our courts can no longer afford to be the exception to the measurement rule. As a nation, and I would suggest to you that as budding lawyers, politicians, journalists, in whatever arena you end up living out your professional lives, that you must insist on strong performance evaluation standards applied across every jurisdiction in the nation. You are all accustomed to the highest level of academic standards here at Syracuse. It's one of the main reasons, I suspect, why you study or work here. Given this, can you imagine a system that condones inconsistent performance standards for America's judges? When I speak to audiences outside the legal system, students, retirees, executives, they're somewhat surprised, but not particularly concerned that judges are not consistently held to high standards of performance. I suspect that this lack of outrage stems from a simmering feeling of cynicism toward the courts, that the courts are an untouchable institution, that the black robe and the bench provide a barrier between the courts and the people they serve. I would suggest to you that that's an unhealthy trend, one that I believe can be reversed, certainly should be reversed, if our judges embrace 21st century measurement systems that acknowledge the excellence of the majority of judges and then weed out the balance of judges who are not serving the public in the way in which they should. Now, the first question that may come to your mind is, why does it matter to any of you? I'm looking out at a group of people who probably can't even imagine needing to go to court unless you want to become litigators. Or perhaps for things like unpaid traffic tickets, or the consequences of a fender bender perhaps someplace along the way. But the truth is that a staggering number of us enter courtrooms every year for various reasons. Consider this. The National Center for State Courts that measures statistics across the nation represent that in 2004-05, 17 million civil cases were filed in state courts across the nation. That doesn't include criminal cases, it doesn't include juvenile cases, those are just civil cases. If we assume at least 2 parties for every civil case, that's 34 million people, 1/10 of our total population, who had to be in court for one reason or another during 2004-05. This matters. I want to take a brief detour here to provide you with a little bit of additional context for the Institute, our interest in this issue, and why I'm standing here to begin with. We first opened our doors just over 2 years ago. Our first major study and set of recommendations was in a report entitled Shared Expectations, Judicial Accountability in Context. We made the deliberate choice to release that report during the 2006 midterm elections. At that moment in time, our home state of Colorado was facing a ballot amendment that would have retroactively term-limited the appellate bench, basically resulting in the firing of nearly half of the sitting judges and justices of the Colorado Court of Appeals and Colorado Supreme Court. The architect of that proposal was able to build substantial support for the initiative. Indeed, initially it looked as if it was going to win by a landslide, in part by playing on the perception of some that judges are unaccountable to the public. The fact is that Colorado has one of the strongest judicial performance evaluation programs in the nation, but most of the voters didn't know that. We timed the release of the report to educate the media and the public about the state's judicial evaluation system, and thus we tried to redirect the focus of the debate to what really mattered: serious analysis of a dangerously flawed initiative and serious consideration of the quality of the judiciary in Colorado at present. During the 2006 election season, voters in a number of other states also faced harsh proposals that would have undermined the judiciary in some way. I want to play a short CNN story for you that will give you a taste of the mood in parts of the country at that time, what our institute ultimately termed the judges under siege malaise that seemed to be spreading across the country.
Hard to believe. Issues beyond control of Congress and local state houses in Tuesday's elections. In several states, voters could limit the power of judges. In some cases, as Gary Nuremberg explains, jurists could be sued or sent to jail for their actions on the bench.
We're not a dead yet! Let Terry live!
The lengthy court battle over whether to withhold life support from a comatose Terry Schiavo angered many on each side and helped highlight growing discontent with the judicial process. Retired Supreme Court Justice Sandra Day O'Connor tells CNN that in recent years, she sensed
increasing indicators of unhappiness with judges, and it was erupting all over the country.
The president taps into that frustration on the campaign trail.
You think activist judges should be allowed to redefine our country and issue new laws from the bench? Vote Democrat.
This year, voters in several western states face ballot initiatives that would limit judges' actions.
South Dakota is definitely the most radical of them.
It's a state constitutional amendment that critics argue would apply to anyone making judicial decisions, even juries and school boards.
It would strip judges of the protection of judicial immunity and subject them to possible monetary fines and criminal sanctions.
People are just finding that the judicial system just doesn't work.
Ron Branson founded Jail for Judges and thinks judges should be accountable for what they do on the bench.
If I violate the law, I have to give an account. If you violate the law, you have to give an account. Why should judges be above the law? And that's what judicial immunity is.
It's not the only judicial ballot initiative this year.
Colorado has term limits on judges.
The 10-year limit would immediately force 5 of the 7 current Colorado Supreme Court justices to step down.
Whether they're extraordinary judges or not such good judges, they would be swept out.
Advocates of judicial restraint say they want to make the judiciary more accountable. Voters get to decide Tuesday. Gary Nirenberg, CNN, Washington.
Although all of the proposals outlined in that story were indeed defeated, it seems clear that the proponents of these measures touched a chord. In Colorado, the term limits amendment ended up with 43% of the electorate supporting it. Our institute recognized this as something of a wake-up call. It seems to us that the public has become increasingly concerned that the system does not provide ample checks to ensure accountability, and that proposals like the ones you saw in the CNN piece might be viewed as a reasonable means of reining in the nation's judges. An outcome, I want to be clear, I would abhor. This mounting public disaffection seems even more evident in states that choose their judges through partisan elections, which, as you know, is at least in part the case in New York. In 2007, there was an Annenberg survey that found that Americans who live in states that elect their judges in partisan elections feel that, quote, judges are just politicians in robes, close quote. But let's drill down a bit more on the contention that judges and courts cannot be measured, that justice is too subjective, too ephemeral to be measured, that it would compromise judicial independence to attempt to measure court performance. I would suggest to you that just the contrary is true. The only real way to answer concerns about the court and to defend independence with vigor is to develop reasonable, objective measurements. Indeed, measurements seek not to determine whether a judge or a particular court system got it right in any particular case, but rather whether the process meets the high standard of integrity and professionalism that the public deserves from its judicial system. Far from challenging judicial independence, performance measurements bolster judicial independence by focusing on the proper neutral metrics of judicial accountability. In my view, we must develop appropriate standards, and the time is now. My youngest child, and we have one who is something of a caboose, complained bitterly when he graduated from elementary school into middle school and he was forced to abandon, satisfactory and unsatisfactory and all of these very obscure rating systems that have nothing to do with A, B, C, D, F. He was outraged that his performance was going to be graded on a standard that indeed everybody would understand and that would indicate who was better than whom. But after the dust settled, and it didn't take very long, he realized that he didn't have a choice in the matter, and he went immediately to, okay, what's it going to take to get me? What sort of performance do I have to turn in order to excel? Our judiciary is no different. Some judges may be annoyed and threatened because they like the status quo better. But our courts need to step up to the plate and figure out what it takes to get an A. Even if justice is too subjective to be measured, we can certainly evaluate efficiency, effectiveness, impartiality. And in order to maintain the best courts in the world, we must set the bar even higher. To that end, I want to talk to you about the reasons why judicial performance evaluation has become such a valuable tool for American courts. I will then review the characteristics inherent in a good performance review system, and finally consider the steps to get there, the what next piece of this analysis. But first, I would be remiss if I didn't point out what all of you presumably already know, and that is the public doesn't get it. They don't understand what courts do or what judges do. 56% of respondents in a 2005 poll conducted by the American Bar Association strongly or somewhat agreed with the following statement. 56%. Now listen to this statement. Quote, "Judges routinely overrule the will of the people, invent new rights, and ignore traditional morality." Close quote. Okay, so what's wrong with that statement? What would immediately leap to your mind about that statement? How about that courts are not supposed to be majoritarian? Courts are not supposed to enforce the will of the people. In fact, quite the contrary, courts are supposed to protect the rights of the minority. How about that judges ignore traditional morality? What's that about? What is traditional morality and how are judges supposed to be upholding traditional morality? The analysis is off track. It's using a set of measurements that are uniquely ill-suited to an analysis of the judiciary. Judicial independence must go hand in hand with judicial accountability. Courts and judges should be accountable to the people they serve without sacrificing judicial independence. So how do we accomplish that goal? What we suggest is that we institute strong judicial performance evaluation processes, or what we call, for shorthand, JPE. By JPE, what I mean is the following. Anonymous evaluation of judges based on set criteria. JPE can provide judges with concrete feedback on their performance, which hopefully promotes improvement. It can also provide the public with information about how a particular judge is performing. Setting up a comprehensive JPE system may seem, at first blush, a bit daunting, but the good news is we already know how to do it. And in fact, 6 states, Alaska, Arizona, Colorado, New Mexico, Tennessee, and Utah, currently do conduct robust official performance evaluation of their judges, and they share the results with the public. 19 other states conduct performance reviews to promote judicial self-improvement or for other purposes. What do these existing systems teach? With respect to setting standards and measuring judges against those standards, we've learned that what we measure is critical. That should be a familiar refrain. You've heard it all your lives, I'll bet. The most important criteria when measuring judges are legal ability, integrity and impartiality, communication skills, professionalism and temperament, administrative capacity, and I would also suggest that the better JPE programs include community involvement as a part of the evaluation mix. For example, in Tennessee, judges are evaluated on, among other things, service to the profession, one of the many ways to foster respect for the judicial system and involvement of the judiciary. How we measure performance along those standards is also key. Information gathering and oversight of JPE is usually undertaken by an evaluation committee in each participating jurisdiction. It is the role of the committee to collect the data about the judge, digest it, and then ultimately transmit it to the public or to the decision-making body. What's important is that this committee must engender public confidence in the performance evaluation system. The committee itself cannot be perceived as or be, in some sense, partisan or the instrument of a political agenda. To that end, the committee should be composed of attorneys and non-attorneys, and its membership should be selected by several diverse entities. In Colorado, the members are selected by the governor's office, the president of the Senate, the speaker of the House, and the chief justice. They each have particular appointments, and the individuals serve for set terms. And in Colorado as well, there's a majority of lay members. While the committee oversees the process, the actual gathering and collating of relevant data should be performed by an independent professional entity or a university. Some of that data already exists and is easily retrievable. For example, as one component of measuring administrative capacity, we can look to the data kept by every court about each judge's docket. That information is available not only in state systems, but for the federal system through the PACER system. Survey data is also an essential part of performance measurement, and that data must obviously be generated independently. Surveys are most effective when they capture a wide audience. For trial judges, the survey respondents should include attorneys who have recently appeared before the judge, litigants, witnesses, jurors, law enforcement personnel such as parole or probation officers, court staff, social workers, guardians ad litem, interpreters, court-appointed special advocates, and magistrates. For appellate judges, the survey respondents should include attorneys, litigants, law professors. Who reads appellate opinions more avidly than law professors? Trial court judges. This is an interesting one, but because, of course, the trial court does read the appellate bench's opinions, takes them to heart, understands whether they are enforceable, whether they make good sense, whether they are well written in ways that few practicing attorneys do. And then other judges on the particular court on which that judge serves. Although a wide net should be cast with respect to the types of individuals targeted to participate in a survey, the surveys themselves should be narrowly tailored to address only that individual's area of knowledge or expertise, or that class of individuals. Survey questions should also be illustrative of the judicial qualities to be evaluated. It's not very helpful to ask a respondent merely to rate a judge's integrity, because that term means very different things to different people. The survey would do better to ask whether, if you're talking about a litigant survey, for example, whether the judge treats all people fairly in the courtroom, whether the judge discriminates on the basis of race, gender, economic background in the view of that litigant, whether the judge gives each side a full and fair opportunity to present its case, whether the judge is prepared for the hearing, and whether the judge rules promptly. Survey participants should also be limited to those who have had direct, recent contact or experience with the judge in question. Surveys should therefore be distributed only to those who have interacted fairly recently with that judge. In Colorado, it's within the preceding 2 years. Another important component of the process is the judge's own self-evaluation. This allows the judge to consider the areas of performance in which he or she believes that they excel, as well as those areas in which that judge believes that he or she needs improvement. Later comparisons to the survey data may reinforce the judge's own perception or may help the judge identify other areas of improvement that weren't so obvious. When I went on the trial court bench initially, I realized that all your best friends didn't talk to you anymore, and that the lawyers who did talk to you didn't necessarily give you candid feedback because they were worried that they might have to appear before you and that you would somehow hold it against them. And at the time, I don't think this is the case anymore, but at the time, Pizza Hut had these little surveys on the tables, you know, that you would fill out as to whether the service was good, the food was good, and you'd drop it off as you left. So I instituted what I called the Pizza Hut survey, and I left very short little questionnaires on all of the court clerks' desks and asked very basic questions about whether people thought that I was doing a good job or what they would suggest that I should do differently. And the truth of the matter was that very few of them were filled out. People were concerned about anonymity. They were concerned that somehow they would be identified, I'm sure. And it was not a very effective process, but I was hungry for feedback. I really wanted to know whether the attorneys who were appearing before me thought that the process was moving along appropriately, whether the litigants felt that they'd been treated fairly, and there wasn't a means of getting that feedback. The other example I have of this is that I went through years of my life where I would go to bar events and sit at a table and nobody would sit next to me because all the attorneys were afraid that they would be perceived as having somehow tried to curry favor and that their opponent would hold it against them in some fashion. So it really is difficult for judges to get legitimate feedback. And one of the most important pieces of judicial performance evaluation is that it feels that legitimate. Finally, once the information has been compiled, the judge should be interviewed directly by the evaluation committee or the chief judge of the court in which he or she works. This allows the judge being evaluated to comment directly on survey results, to point out perhaps inconsistencies or small response rates that should cause the commission to question whether the data is accurate. And it also allows the committee to place all the information about the judge in greater context. So if, for example, the judge has a really bad record of what we call pending cases, open cases that are too old, that he or she has not gotten around to, maybe there's a good reason for that. Maybe this person had a death penalty murder trial or a major tort case that took a huge amount of time. And that's the kind of information that the judge is in a position to be able to recount to the Performance Commission before they make their determination. Measuring performance, of course, is only a piece of the task. Equally important is using and distributing the information effectively. Again, we have to remember that JPE serves these dual purposes, the one of helping the judge to improve, but the other informing the public about this judge's performance and about courts in general. Depending upon the goal of the particular evaluation, that second piece can be handled differently. All judges, or all judicial performance evaluations meet the first criteria. They're an opportunity for self-improvement. In 2002, in Washington State, there was a survey of trial judges who were evaluated, who felt that the survey feedback was indeed beneficial and provided them with information that was not previously available. In Colorado, we are at this moment in the midst of a judicial performance evaluation survey with judges around the state to get their feedback about whether it's working well for them, what additional information they would like to have, how they use this information, and whether it shadows them, whether they feel that it somehow impinges upon their independence or constrains them from ruling in particular ways. Performance evaluations solely for the purpose of self-improvement are usually kept confidential. In some states, performance evaluations occur every 2 years, and they are kept confidential under those circumstances. However, on retention years, which is the years in Colorado that we stand for retention on the ballot, although there's no opposition, it's just the name is on the ballot and people can vote for or against that judge. In those years, then, the information is disseminated to the public. The benefit of the system then is that the Performance Evaluation Commission is able to communicate to the public whether this judge has been doing his or her job. There is less opportunity for shading by a particular commission if you have historical data on a judge. One of the concerns that people frequently raise is that the particular makeup of a performance commission may suggest a partisan balance. If there is historical data on that particular judge, it's less likely to be susceptible to that particular concern. When the information is of obvious public concern, for example, in anticipation of a retention election, it has to be made readily available to the public. Sources of dissemination include the internet, public buildings such as courthouses and libraries, direct mail to voters, newspapers, and in order to place the results in context, Statistics and benchmarks are usually accompanied by a short narrative, giving the judges biographical information and explaining how the performance evaluation findings should be interpreted. Where appropriate, the narrative also includes the committee's recommendation on retention. That does occur in Colorado, that the committee recommends that the judge be retained or not. Retention recommendations are often based on the judge meeting those benchmarks, those required thresholds. As a general rule, the judge may review the draft narrative and meet with the evaluation committee before it's finalized, so if there's language in there to which the judge objects, there's an opportunity to address that. In some states, this official, robust review of judges has been going on for over 20 years, and Colorado is such a state. But no system is perfect. Improvement must be made in the quality of the data collected. Survey questions need to be re-examined and recrafted, and rating scales re-examined. Surveys should also encourage respondents to provide additional comments, and that's an area in which we're continually attentive because that can potentially undermine anonymity. If a particular attorney says, yeah, I think this judge is okay, but boy, when I appeared in this case, he or she did this outrageous thing, and if you pass that information along to the judge directly, frequently the judge can remember which case it was, and so the anonymity concerns become very real. In addition, we must increase the level of participation in surveys. Only 54% of the attorneys responded to surveys in Washington in 2001. Less than half responded in New Hampshire that same year, and only 1/3 of all surveys sent out in Alaska garnered responses in 2004. A low survey count for any particular judge can obviously skew the numbers and make benchmarking far less valuable. A final aspect to increasing data quality is knowing what not to collect. Simply put, some measures don't cut it. For example, one state, this is my favorite, one state measures the number of questions that an appellate judge asks during oral argument. Well, guess what that encourages? That encourages a very hot bench that asks a lot of questions because they know that they're being measured on that. Does it encourage a good, thoughtful consideration of the case? Does it encourage a well-written opinion? Does it encourage a prepared bench? I would argue with you that probably none of those are directly related to how many questions a judge asks from the bench during oral argument. And so that measure is clearly off track. Now I need to come back to probably the most important aspect of what I'm saying, and that is I need to be very clear that we are not seeking to measure outcomes of various cases. Judges must be evaluated on the basis of their capacity to provide due process in an efficient, effective manner. Their capacity to render clear, legally well-reasoned decisions, not politically correct decisions. We must also improve the dissemination of this information, and this goes to the heart, I think, of the intersection of disciplines that this course represents. The first step of getting this information into the hands of the public has made solid strides in the past several years, but the second step, getting them to pay attention and to understand what it is they're looking at, is much more daunting. Voters still do not know their judges. We need better ways to get the public's attention and educate them about the judges who serve them. A third very closely related area for improvement is increasing the public confidence in these systems. Citizens need to believe that evaluations matter, that the judges want to improve and will act constructively on the information provided. There's some criticism that these systems don't work because performance commissions rarely recommend that a judge not be retained, or that a judge be voted out of office. That is both a popular criticism and also a misleading one, and here's why. Last year in Colorado, there were approximately 130 30 judges eligible to stand for retention. Approximately 20 of those judges chose not to stand after they had received their performance review. Not all of them made the decision on the basis of their performance review. Maybe some of them were already planning to retire, but the timing is a little suspect. And the truth of the matter is that some significant proportion of them chose that because they would have had a poor performance evaluation. So the point is to remove judges who aren't doing their jobs well. The point is not public humiliation or some sort of public outcry. We want outcomes that improve the system of justice, not necessarily an outcome that causes someone to run some kind of a gauntlet. Another concern about the composition of the evaluation committee is whether there should be a preponderance of lawyers, a preponderance of lay people, members from one political party or another. There are some commissions that require a bipartisan balance. We tendered that as a possible improvement to Colorado's system, and the legislators rejected it as, in fact, infusing a political component that wasn't already there, which is sort of interesting. These concerns are all valid because they are all directed toward what is most likely to gain public confidence. Judicial performance evaluation in the end analysis must be apolitical, and strong performance on the core measures, legal ability, impartiality, professionalism, and the like, must be of equal interest to all citizens, not just lawyers or lay people, and certainly not of disproportionate interest to Democrats or to Republicans. These criteria must be embedded in governing statutes or rules so that each performance commission is applying the same set of standards. So, where do we go from here? If you were convinced that this was the right thing to do, how could it possibly be implemented? I believe that every court in the United States at every level should strive to implement a comprehensive program of judicial performance evaluation. And, perhaps more importantly, I believe it's doable. Our institute is committed to working with states seeking to establish or improve judicial performance evaluation programs. We continue to offer policy recommendations to legislators who must grapple with the political tug-of-war that often accompanies discussion of this issue, and we meet with key media to educate them about the importance of a strong and accountable judiciary. Despite complaints that this topic is way too arcane for public consumption, and despite complaints that we still haven't figured out a way to put a human face on it, which is what I was talking to some of you about at lunch. We will do all of this and more because we believe that judges are servants of the people and that public criticism of the courts is very real. It's not enough to hide behind the Oz screen of judicial independence to escape the loud and frustrated crowds at the gate. The public deserves a judicial system that is efficient, effective, and fair. And I believe that only a truly accountable judiciary can deliver on that promise. I thank you for your interest in this arcane subject that indeed does speak to the various disciplines that you are studying. And now what I would like to do is open it up to comments and questions from all of you. And they needn't be just directed at me. You could just interpose a comment that you think may elicit some response from some of your classmates. Yes, sir.
Regarding this JPE, is it a commission that sends out the evaluator, the recommendation? Okay. Is the recommendation itself necessary? In other words, would it be, I mean, in the direct mailings, would it be maybe a little more humble to John Q. Voter to just give him the data, maybe even show where this judge falls, related to his peers or her peers, without giving that actual recommendation?
Different commissions around the nation do it differently. You're absolutely right. Some commissions synthesize the information and then vote among themselves as to whether this individual serves or should be retained or not retained or reelected or not reelected. Other commissions don't. They just summarize the information and show some benchmarks and leave it to the public to make their own decision. I happen to agree with you that it's a little more humble to do it without a recommendation. I think the commissions feel that why should they put all of their time and energy into serving and digesting this information unless they have some role in trying to communicate their opinions to the public as well. But it does predetermine outcomes to some extent. The public tends to vote along the lines that the commissions suggest. And then you get into the really interesting circumstance of when a commission splits and you have a bare majority voting for retention, and that vote is reflected in the ultimate piece that goes to the public. And then it's very interesting to follow whether the public actually votes in favor of retention or not. And the percentages are down, but they do still tend to vote for retention. So I agree with you. I mean, I think it's a more honest system for the commissioners to just digest the information rather than try to interpret it.
What do you think are the best ways that we can ensure that these commissions are absolutely nonpartisan? Because the worst thing that can happen for public perception is that the commissions begin to be viewed as tainted. Even the appearance of impropriety would double public cynicism in the court system. So how can we absolutely protect against partisan corruption?
What I can tell you is that the states where this has been in place for a couple of decades, the appointment process itself is either statutory or constitutional. The fact that different entities have appointees to the commission. The balance of attorney, non-attorney is statutory or constitutional. Arizona, I think, is the only place where it's constitutional. Everybody else is statutory. And the rules of the commission are disseminated for public comment. They're ultimately adopted by the commissions, and those govern their performance. So it's process. It's like exactly what we're talking about. It is the integrity of the process that assures that nobody can commandeer the commission and point it in a political direction. What I can also tell you is that we have started a judicial performance evaluation working group, which is a monthly telephone call that involves the executive directors of judicial performance evaluation commissions around the nation to share their expertise. The question that you raise is a question that was raised by the California court system that is looking at implementing judicial performance evaluation. And so we offered it to our working group. We said, have you, in the course of the history in your state with judicial performance evaluation, has there ever been a circumstance where the commission either actually was or was perceived to be an instrument of a political agenda? And to a person, they said no. Now, I can tell you that last fall in Colorado, there was a dicey near miss when the commission had a political agenda, or was perceived to have a political agenda as to a particular judge. The commission ended up voting to retain, although not on a unanimous basis. And then there was a campaign against that judge that came in from the wings, from a political group. And the suspicion was that the losing members of the commission came at that judge through another means. They lost, the judge was retained, and the integrity of the process was preserved. But it clearly is something that deserves attentiveness and real resolve to assure that it does not become partisan. We're in the process of setting up an office that staffs the commission, and I think that will probably contribute to the consistency and the regularity of the process in which they're involved and make it less susceptible to veering in one direction or another. And that may be part of the key to this as well, rather than letting it be staffed sort of on a volunteer basis.
Well, certain cases are going to inherently be more political than others, with parties dividing how certain issues should be judged. How do these evaluations consider what cases to evaluate the judges on? I mean, do they read every opinion that the judge writes and evaluate whether we reach these broad goals that the commission sets as the standards for good judging, like capacity to render due process, or how do these political type decisions, do they get more weight?
No. And let's sort of cordon off the world that we're talking about first. We're talking about appellate judges right at the moment, because infrequently do trial judges get themselves into a posture where they're commenting on political issues. I mean, every once in a while there'll be a case that will come before a trial judge that is inherently sort of a hot-button case. But by far the preponderance of those cases end up at the appellate level being resolved there, and it is there that the policy concerns come into play. So we're talking about evaluation of appellate judges. The answer to your question is that data collection is not focused on hot-button cases. Data collection is either random or continuous, depending on the state. In Colorado, it's continuous. So every time an attorney closes a case before the Colorado Supreme Court, he or she gets a questionnaire about the judges who were involved in that case. So that kind of continuous data collection is not skewed by a disproportionately high-profile case. So it's a data collection issue in the first instance. But then we come back to the question of what if you have a partisan performance commission that doesn't like the way that a particular Supreme Court ruled on a hot-button issue? How can you keep them from making their evaluation revolve around that particular case? And the way you keep them from doing that is by identifying the data that needs to be reviewed. You want to look at case management data. You want to look at surveys from respondents across the board. You want to look at surveys from law professors, from law clerks. And all of that data has to be digested and provided to the public. So even in the worst case scenario where you had a commission that had a partisan agenda, that commission is still going to have to report out to the public the data upon which it based its opinion. The compilation of survey data from all of the sources, the review of the case management data, the analysis of the opinions from the law professors, whatever the data collection process is. For them to reach a partisan viewpoint based on 1 or 2 or 5 opinions will be pretty transparent. Not grounded in the analysis of the data. So it's not impossible. It goes back to that question of why do you want them reaching their own opinions anyway? Why don't you just use them as a data collection entity through which this data is filtered and then provided to the public so they can reach their own conclusions? And that then avoids that possibility that the commission will skew something based on an unpopular decision.
Well, isn't the type of data collected, I mean, the choice of what data counts, isn't that also a skewing factor, or is it just... It's
not up to the commissions to make those decisions. That's part of the answer. That is either statutory or rules-based, and that's embedded in the process. So they don't get to decide that this time around they don't want to listen to the litigants for this particular Supreme Court justice because they have their own viewpoint about which way they want to go.
It seems in some ways, I mean, I know the Colorado system isn't perfect, but in some ways they're advocating the exporting of that system. Excuse me. Because it's been around for a couple of decades. I'm down Colorado. Coffee.
New Mexico is pretty good,
yeah. I wonder if you think the system has not worked well because this term limit proposal was in Colorado. and got 43% of the vote. So does that actually indicate that this evaluation system you're advocating doesn't meet the goals of educating the public?
Well, I guess what I would say is that I think it meets the goals of providing a really excellent judiciary. And Colorado's judiciary routinely scores really well on national surveys for integrity and capacity and experience. So I think it works to promote a good judiciary. Do I agree that it clearly has not convinced the public, at least 43% of the voting public, that it works to achieve that? And I think the answer is yes. And that's the survey to which you referred, because we decided to go out in the field and figure out who voted for this amendment and why, and what they were concerned about. And over 90% of the respondents to our survey had no idea that there was a judicial performance evaluation program in place in Colorado. And then of those 90%, 95% said that if they had known that and if they trusted the system, they would not have voted for the amendment. So, I mean, that's easy to say sort of 20/20, but the point is that we've done a terrible job of communicating, using the media, using other methods of getting information out to the public. I can speak in Colorado, it's not so bad now, but a year ago, I could speak to a room full of attorneys, and they wouldn't all know that we have a judicial performance evaluation system. If they're not litigators, they wouldn't even know that it's out there. So, I mean, there was a huge information gap there as to what was going on and whether the public had reason to trust what was going on and therefore could believe that bad judges would be weeded out. What's our time?
I was just curious as to, kind of similar to that question, does this system involve, because I feel like the public is probably voting more on the issues relative, because this performance system seems to really measure competency almost in terms of, like I know some of the factors you said, like administrative ability, communication skills. Does the aspect of impartiality take into account, like with the professors and sort of some of the legal scholars, when you have sort of that gray area of the law where judges do have the ability to, you know, either through precedent or do have the ability to, where people feel that they're creating law per se, does this evaluation system using the legal scholars and professors actually evaluate the degree to which in a appellate opinion a judge may have exercised that right? So you can almost from a score standpoint be able to say, yes, you know, legally this judge was in a position where, you know, maybe this was an issue where there was a gray area, but they actually went very tight to the line, or they were a little bit more broad in terms of their interpretation, because it seems like that's probably the big hot button area where the public in general tends to evaluate judges. They probably don't, or maybe they don't. It seems like they don't probably look at some of the more technical details of what a judge should or not do. They would maybe more vote just on the big issues, and I'm wondering, do we actually measure, or does this system measure judicial discretion within sort of, from an actually legal standpoint?
Two answers. The first answer is the system in some states tries to measure aspects of that that can be objectified to some extent, such as for an appellate judge, does the judge confine him or herself to the facts of the case? That's an interesting one because appellate judges can sometimes make up facts. Now, the problem with that is that it requires somebody to read the records. And performance commissioners sometimes do that. Attorneys can comment on whether the judge colored outside the lines and found facts that weren't part of the lower court record, and so there's some information that comes back on that front. There is a category that asks whether the judge applies existing precedent appropriately, and appropriately, of course, is a linchpin because that's in the eye of the beholder to some extent, but it at least tries to focus people on is this judge aware of precedent, and does the judge either apply it or distinguish it, or is the judge somebody who doesn't care much about precedent? That's about as far as it goes, because it's viewed as an invitation for political involvement or political opinion. But let me come back to something that you said that's really interesting to me, and that is there's this dichotomy between what people want in a judge when they walk in a courtroom and then what they think about when they think about an appellate court. When they walk in a courtroom, what they want is somebody who's fair, even-handed, well-prepared, efficient, respectful, good judicial demeanor, renders prompt decisions, all of the procedural fairness stuff. They'll say they want somebody who's on their side, but the truth of the matter is that they understand that if somebody's on their side in a particular case, that same judge is going to be on the other side in another case, and they get the fact that that's not what you really want from a judge. So that's kind of the trial court piece of it. When you get to the appellate courts, what people tend to start to think is appellate judges are just policymakers. Back to the Annenberg stuff, just policymakers in black robes. And so I want them to make policy my way. Part of this whole process is educating people that appellate judges are not policymakers either, that appellate judges have a very distinct role in our system, and they should be carrying out that role. Now, it is more difficult, admittedly, to develop performance measurements for appellate judges than it is for trial court judges, because there is less of the procedural fairness aspect of all of this that jumps out at you. That's very clearly a part of what you want. Demeanor, I mean, you care if the judge yells during oral argument, but it's not that big of an issue. It wouldn't be as important as it would be if you had a trial court judge who was yelling at witnesses or who was routinely in a terrible mood. So demeanor, efficiency, that's more difficult to determine because they're working as a bench. And so you may have the most efficient judge in the world who can't get opinions out because he or she's on a panel with some slackers who don't get their work done or who don't get their dissents done or whatever it may be. Now, there are ways to do that. I mean, there's data that can be teased out of the system that tells you when the case was assigned to a particular judge and when the first draft came out, that kind of thing. So it's possible, but it's more difficult. And then there's the whole notion that the only work that that judge does is issue a written opinion. That's all you really have to base your performance review of that judge upon. It isn't like watching somebody in court day in and day out. And so you do need more sophisticated measurements that allow people to focus on the right aspects of a judicial opinion. And I readily agree with you that it is more susceptible to the possibility of infusion of political agenda than it is when you're measuring a trial court judge. This is always why it amuses me no end that states like yours that appoint the appellate bench and elect the trial court bench, I mean, if you were going to do one and not the other, I've always thought that you should elect the appellate bench and appoint the trial court bench, because the trial court bench is absolutely apolitical anyway, has very little opportunity to issue political decisions, and why do it that way? But, I mean, you are very much in the norm. The states that have split systems do tend to split them in that way. The performance measures for appellate judges, looking to other judges on that court or on an inferior court. And then I think it's brilliant, and this is New Mexico's idea, by the way, to include law professors, their analysis of the opinions, and to include law clerks, which is also really interesting, because clerks who have worked for a particular appellate judge, once they get away from it a little bit, they can comment not so much on their own judge, because they still are very reticent about that, but they can tell you about other judges on that court if they believe that their responses will be anonymous. So it's hard, but it's kind of the best game in town is I guess, the ultimate analysis.
Well, I wonder how you would compare that, I'll try to pop less this time,
to another evaluation system. It's not sitting judges, but prospective judges, which the ABA does, right, for all federal nominees. And for Supreme Court nominees, they enlist this 13, 15-member committee and do lots of interviews with associates and former clerks and enlist law professors. In fact, SU was enlisted for that evaluation, the most recent round of nominees. And the criteria are very similar, the ones you've laid out. And they don't want to look at whether they got the law right. They're supposed to be looking at professionalism, integrity, impartiality, temperament. In fact, the list, I think, compares pretty favorably with the list, the ABA list with the one you produced. And yet, in terms of public confidence, right, I mean, at least some measures of public confidence suggest there's not much confidence in it. The Bush administration booted the ABA out from the evaluation process. And they certainly have been there for a long time before when they were in the loop, but I mean, it's become, it seems like it's controversial. The fact of this evaluation seems like it bumps along, and when the evaluation of professionalism coincides with, say, what the administration wants to hear, or what senators want to hear, it's non-controversial. But when it's out of line with the expectations of what those who are appointing or backing the nominee, then it becomes controversial. So that's a system, admittedly, not of evaluating judges who've been sitting on the bench, perspective, but it has many of the same criteria. It involves professors, it involves lots of people, yet I don't know that it's seen by the public as apolitical. And it seems to be seen by some important actors as political. So I was wondering what your reflections are on that process.
Well, I guess I would start with the point, and maybe it's debatable, but I bet it isn't in this audience, that what you want is an impartial judiciary. That that's the objective of this process, as well as of any sort of nomination process. You want an impartial judiciary. You don't want 10 Republicans and 10 Democrats, 10 pro-prosecution, 10 pro-defense. You want each individual to be impartial and balanced. That particular statement is not necessarily one that every group would endorse. There definitely are interest groups who want, and they're on both sides of the political spectrum, who want judges on the bench who are of their particular political ideology. In my view, that literally gives away the store. To say that you want a liberal judge or you want a conservative judge presumes at the outset that that's the right thing for a judge to be conservative or to be liberal. The right thing for a judge to be is to be impartial, to have no political agenda, to park it at the door. I fully recognize that to some extent that's an idealistic perspective, but it is an idealistic perspective that has to be out there as the ideal. We cannot give in to the notion that human beings are human beings and everybody has their own biases and I want the biases to go my direction. Because the minute we give in to that, we minimize, we cheapen the judiciary. And we buy into this public perception that they are just policymakers in robes. So it is akin for me, I relate lots of my life lessons back to when I was on the trial court bench, but about the second or third time I had a jury trial, I had the attorneys before me and they're doing voir dire on the prospective jurors, the veneer. And there was some hot question that came up that I wasn't going to let one attorney or the other ask. And so we excused the jury and we argued about it on the record outside the presence of the jury. And I said to the attorneys, what we're looking for here is an impartial jury. And the question that you're asking is skewing issues in the minds of those jurors before we even get to presenting the evidence. And this one attorney who had practiced before me for a while, and he was a friend, he looked up at me and he said, no, you don't get it. I'm not looking for an impartial jury. I'm looking for jurors that go my way. He can look for jurors that go his way. I'm looking for jurors that go my way. It's your job to balance it all out and to try to figure out if this is an impartial jury. And it just encapsulated for me what all of this is about. there are clearly folks out there who want jurors that are going to go their way, and folks on the other side that want jurors that are going to go their way. I think that's the wrong way to run it. I do think that the ABA standards and that the ABA process, for the most part, was a good process. And I think it did produce candidates who were well qualified. I do not think that it was politically slanted in one direction or another. I think the ABA came to be associated with a Democrat liberal agenda because of some of the positions that they endorsed, and that in turn tainted their judicial review process. But to the best of my knowledge, and I have some familiarity with the process, the criteria that they used were absolutely the right criteria. The kinds of analysis that they were undergoing was appropriate, and it wasn't that they were trying to identify liberal judicial candidates. So I think that these measures, and we use similar measures at the nominating commission level as well, the same sort of thing you're talking about, and indeed one of the scholars at the Institute has written a law review article on how to use prospective performance evaluation measures in election states. How you might set up a commission that would review judicial candidates along these same criteria and then provide recommendations to the electorate. Norman Green said to me this morning he thinks that might be unconstitutional, but there you go.
That's for the courts to decide.
That's for the courts to decide, that's right. Yeah.
When I was a reporter covering judicial elections and for the courts, but then occasionally elections, one of my least favorite assignments was to evaluate the candidates. In other words, write a story about who was running. And I did what many reporters do, which is just try to talk to as many lawyers as I could, and you could never get anybody on the record to be critical. Everybody who was positive said the same things. The candidates walked around with their resumes into their lapel, and that was about all you got out of them. It was a dreadful assignment because you knew you weren't getting the real story. So I would have embraced hard evidence, detailed surveys of the sort you're talking about. Then why in Colorado, for example, at least as you portrayed a couple of years ago, there was widespread ignorance? Was the press just not interested in these, and why?
I wish I could tell you the answer to that. We've enlisted the Post in a campaign to try to educate the public, and they're very committed to it now. But we went through a long period of time where it was just ho-hum, nobody cared. There was a perception that judges would routinely be retained in office, that the electorate was not paying attention, and the media just was not interested. We couldn't even get the media to publish the narrative profiles that contained the distilled information and the recommendations. They wouldn't give the Judicial Performance Commissions the ink in the paper, and so it went to a purely web-based dissemination of that information, and people stopped paying any attention at all to it. They didn't look it up. It went out in the Blue Book, at the end of the Blue Book, which is our voter guide that comes to every registered voter. And routinely, it was at the end of the Blue Book, and routinely people didn't even know it was there.
Is it any different in states with partisan elections?
New Mexico's judicial performance evaluation process is a little higher profile because they do have contested elections, and people pay a little bit more attention to what's happening. So yes, there is a difference in states where there's perceived to be a real contest. And then if somebody goes after a particular judge, if there is a campaign against a particular judge, then the reporters will start to pay a little bit of attention and will pull up the information and start to talk about some of the criteria that are included within the report. But I mean, it is largely a non-issue in Colorado, but for these initiatives, and the term limits initiative is back, by the way. The way in which the term limits initiative was framed in the last election was retroactive. It is now framed in a prospective way, which makes it probably more palatable, and therefore I think it's think it's a running question as to whether the electorate will pass it this time around.
But your description, though, of the media's lack of interest is a pretty depressing statement about their sense of responsibility about educating voters.
And I think to some extent it's back to the who cares. Why should we care? And the truth is that it matters so much. You know, I mean, think of the statistic just about divorces, that 50% of the American public is going to undergo a divorce. That involves a judge in most instances, and hopefully a judge who's thoughtful and fair and who understands the law and who's paying attention. You know, it is so clear to me that this is a hugely important issue that people just are not paying any attention to. Justice O'Connor, you know, in addition to her mission about the independence of the judiciary, she also has a mission about educating people about the courts and what they do. And she's developing, through some of her partners, an interactive computer game, essentially, to teach kids about what courts do and how important it is, because she's concluded that the absence of basic social studies at the middle school and high school level is part of what gets us into this plight, where people misperceive what courts are supposed to do. When it comes down to what they really are supposed to do, they don't show a level of interest or attention. So maybe it's right that part of the root of this lies in the fact that people don't understand. You know, the old saw, not so old, that more people can name the Three Stooges than the three branches of government. That's in a 2006 ABA survey. More people can name the Three Stooges than the three branches of government. Not good.
There's nothing so disappointing to some of us than to stand in a voting booth and see judicial candidate names and not know who's the incumbent, not have a clue who they are, and either take a pass or do something maybe even worse, which is vote randomly based on party or some vote on the sound of a name, or just it's not good.
It's awful. And our recent survey that we did in Colorado, I'm grinning because this is so funny. If people don't know about the judicial candidate, indeed they vote on a very random basis, frequently on the name, whether the name appears to have some sort of ethnic echo that they like, or on the basis of gender. But guess what? Men are more likely to vote no on somebody that they don't like. Women are more likely to vote yes on somebody that they don't know. Isn't that interesting? Women are willing to give this person the benefit of the doubt, and they'll vote yes for the judges, even if they don't know who they are. Men, on the other hand, if they don't know who they are far more likely to vote no. Interesting, huh? Yes.
I wanted to ask you what sorts of people would be involved in the commission that receives the data based on the JPEs and regurgitates it back to the public. I mean, could there be any kind of guarantee that, based on what judges can do politically and attend certain events and basically show some support for their partisan views, how can there be a guarantee that that members of this commission would not be somehow politically connected to the judges that they're supposedly regurgitating information about?
Come at that question from New York. In fact, in Colorado, judges can't even attend their precinct caucuses. They can't attend a political fundraiser. They can't give any political contributions. It's really a very stringent environment with respect to requiring judges to refrain from political involvement. The Democrat-Republican makeup of the statewide Judicial Performance Commission at present is relatively balanced because of the appointments that have been made over the course of time, and by virtue of the fact that they are tied to the statutory criteria. There's not a lot of room for them to all decide that the particular justice whom they are evaluating they think is liberal, and they don't like that, and so they're going to recommend against retention on that basis. Again, because they have to tie it back to the data. They have to benchmark against data that they've collected or the commission has collected and data for other similarly situated judges or justices. So there's no ironclad guarantee that it's not going to happen. It's not going to happen in Colorado for the reason that you suggest about cronyism, political cronyism. But again, the possibility that a particular commission could rally against a judge based on political ideology is minimized in the states where judicial performance evaluation is well handled, but it's not entirely an impossibility. You're right. Yeah.
Do you have a sense of what sitting judges think of this evaluation process?
To start with, I was one.
Right.
And I went through performance evaluation, both as a trial judge and as an appellate judge. And I'm very familiar with how the Colorado Judiciary perceives it. There are some who perceive it as a very positive thing, that they have an opportunity to get feedback and that people have an opportunity to vent or to express their views about a particular judge. I think the entire Colorado Judiciary understands that it's a component of having the kind of system we have where judges are not elected. That it is the accountability trade-off for a retention system where judges don't have to stand for election. And there is such a horror of elections in our state. We've had merit selection since the 60s. Before that, we had very partisan elections where people were routinely voted out of office because they rendered decisions that were not politically popular. So the Colorado Judiciary, I would say that a small majority is begrudgingly okay with all of this. There is a minority that actually welcomes it, but there is no one that would toss it out.
When you speak about impartiality, I assume you're talking mainly about like an idea of equal justice, that no minorities are being judged unfairly. I mean, that...
No, I'm talking about not prejudging a case.
Okay.
Coming to the case with an open heart.
Well, I guess the minorities being prejudged unfairly would be just a result of a type of bias. And I was wondering if there was any evaluation of the judges based on decisions of whether there's a racial bias or whether people with certain last names are getting certain types of decisions more favorably. Like, if the evaluations are considered generally, I would consider minorities who have an opinion of bias to be not considered very heavily. If only 10% are consistently treated unfair, then only 10% of the evaluations are going to reflect that. Is there some way to...
Well, there's a question on both the trial court attorney survey and the litigant survey that said, does this judge treat people equally, irrespective of race, gender, or socioeconomic status? If you had a judge who had a high proportion of no answers to that question from attorneys or from litigants or from some combination of attorneys and litigants, that would clearly show up and would be a red flag. And that has happened. That was a reason for a do not retain recommendation a few years ago. That component and demeanor, judges who are arrogant or angry on the bench, tend to be the two factors that are the most likely to produce a do not retain recommendation.
Last year, the first-year class had Penny White come to speak to them, who was, for those of you who don't know, a justice on the Tennessee Supreme Court who lost the retention election after a lot of special interest groups brought up decisions about, I think, the death penalty. And in that case, the committee, the evaluation committee, did recommend her, and yet she still lost. There was some sort of commission that recommended her, and yet she was defeated. Would the public be better off, or the judiciary be better off, if the commissions themselves were making the decision? Because I think it still allows these interest groups to come in you said a minority or a political view on the commission could still go out and have ads made up against certain judges in the retention elections. Would it be better off if the commissions themselves were making the decisions and it never even went to the public?
Let me first address the Penny White component. Penny White was appointed to the Tennessee Supreme Court very shortly after she was appointed. She joined an opinion overturning a death penalty. She joined it, and then came up for election, and there was a political movement against her that ousted her from office. In fact, at the time, Tennessee did not have a full-blown judicial performance evaluation system in place, and she has said that if it had, she thinks she would have had a better shot of working against that political tide because she would have had real data to demonstrate her performance. And she is actually an advocate of robust performance evaluation. But now, let me go to your fundamental question, which is, do you really want the public voting on this? Wouldn't you rather have the commission that collects the data making the decision? And that actually is sort of directly contrary to the point that you were making, that you don't want the commission interjecting its opinion at all. In D.C., that's the way the system works. The D.C. Performance Commission actually decides whether to retain a particular judge. And there clearly are advocates of that viewpoint. The pro is that those are the people who have the most information, those are the people who are invested in really evaluating that judge, and that's where you ought to leave the decision. I happen to be an advocate of public involvement for a couple of reasons. First, even if we have low voter turnout and if we have people who are voting without understanding what they're voting for, I like the notion that judges are ultimately accountable to a public, and that we have no place to go but up in terms of educating the public and investing them in this process. And then there's the sort of corollary point that it is an opportunity to raise public awareness, to try to get the public to understand the role of the courts, the importance of the courts. And I would hate to give that up. If there aren't retention elections, if it's just an inside commission that is making those decisions, then you lose that voice, you lose that sort of megaphone for the issues that comes around on a regular basis, where you can at least hope to involve people in the importance of the decision. So yes, that happens. I'm not an advocate of doing it that way, but there certainly are folks who are.
Are you familiar with there are a handful of websites, I don't know how many there are, but I've seen a handful of websites that are open forums for members of the public anonymously to post comments about judges? Are they simply a gathering place for really unhappy people who hate the courts, or have they ever become anything more than that?
There's an organization called HALT. Are you aware of them?
Long time aware of them, yes. They've been around forever. Help Abolish Legal Tyranny was the original name.
They're morphing into a little bit, yeah. They're morphing, I think, into a little bit more legitimate advocacy group for litigants. For the most part, those sites are largely just pools of people who have real gripes against the system, and they usually do have a political agenda. Back at the beginning of the summer of '06, I called the man who was the Jail for Judges advocate. I thought, I ought to be able to talk to this guy. I ought to be able to figure out what his real concern is, and we ought to be able to think this through, right? He ought to be able to understand that this is not the right way to go. On the other hand, maybe he has some legitimate concerns. Well, oh my gosh. He was a disbarred attorney from Southern California. He was a conspiracy theory advocate about the courts and what judges had done to him. He had foreclosures. He'd been through bankruptcies. I mean, he had a litany of complaints that were as broad as they were deep, and it was impossible to determine the legitimacy of any of it, but he was not interested in being reasonable. He was interested in an agenda. And there are, I would love, if anybody has any information about this, I would love to connect with a website, an organization of litigants who just want to improve the courts, who have had experiences that cause them to think that the courts are not as good as they could be and want to work to improve them. There's a group in Colorado of plaintiffs who've been through medical malpractice cases, and they banded together in order to support legislation that would require doctors who had been disciplined in one state to have to report that in the state to which they were moving. And so they formed sort of a lobby group, and I've been in touch with that organization, and that's kind of a subset of what I would like to find more broadly.
Don't you think that if there were more constructive outlets like that, you might nip in the bud the sort of people who start out with a legitimate gripe or who had an unhappy experience for possibly real reasons, but then it metastasizes. They really become obsessed, and there are lots of people out there who have taken it to another level, and then nobody listens to them.
Yeah.
And then they take it to yet another level.
I absolutely agree with you. Absolutely, completely agree with you. And it's particularly egregious with divorce litigants because it cuts so close to the heart. You know, if they've had a kid taken away from them, or lost their life savings, or whatever it may be, and they just completely lose their perspective, and nobody will listen to them. Nobody will respond to them. And part of the problem is that in almost every state, complaints against the judiciary are not taken seriously. If they rise to the level of dishonesty, truly an offense susceptible to discipline, breach of the Code of Judicial Conduct, then every state has a judicial discipline entity. But in many states, the proceedings for those entities are not public. That process is very closed. And there are not sort of interim audiences for those kinds of complaints. You know, I'm not alleging that this judge is corrupt, but what I am saying is that he didn't pay any attention whatsoever to my case, and it ended up that I was treated very unfairly. So would somebody please listen to me, and would somebody please try to make sure that that doesn't happen again to another litigant? And there isn't a forum for those kinds of complaints to be heard. You probably have experience that would document this. I can guarantee that if somebody opened up a phone line or a website to receive those kinds of complaints, they would be inundated. And that just speaks to the need for genuine opportunities to curb that kind of judicial misbehavior, to improve it, to watch it, to assure that it isn't the norm. I think there is a perception, and sometimes this is true, that a judge's courtroom is a fiefdom, and what happens there is whatever the judge wants to happen there, and there's nothing that anybody else can say about it. It's just the wrong approach.
We are out of time.
We're out of time.
I want to announce that the Law Politics Media class will reconvene in about 15 minutes. But I'd also like to take the opportunity to thank Justice Kourlis.
Thank you to all of you for your attention. This obviously is one of my favorite subjects.